Welcome everyone to this evening's episode of Stark Financial Group um, Mentor Group meeting. Tonight we're talking about signatures. Um, I ended up in a hotel in the middle of nowhere, and I'm probably going to be here for a bit, so I decided to dig into a bunch of instructional stuff on different things that have been coming up the last few weeks. So signatures has been a big one. Now, we all know, as a matter of fact, that the signature has value. Okay. There's a lot of things kicked around about like, how do I sign or, what is a signature or whatever. So I'm going to get into the actual laws of it, but just, understand this is that the it's not so much that the signature has value, it's that they need a surety. They need somebody. So if you want to know more about suretyship, there's a dozen books on it, right? They go all the way back to the 1700s, um, talking about the law of suretyship. Okay. Suretyship is you're the one guaranteeing something. Okay. So you are, as the surety, you are the guarantor. And then whoever you're guaranteeing for is the guarantee, right? And so how they get you to do that, enter into contract and become the surety, is through signature. Sometimes it's unilateral, which means one signature. Sometimes it's both of them, right? Both sides of the table. All right. Now, for the purposes of trust is a three-person, understand what I'm saying here, three persons. That means it can be a natural person or a legal person, right? It can be artificial or actual substance. So a trust is a contract between three people, a grantor, a trustee, and a beneficiary. The grantor is the one giving the property. The beneficiary is the one receiving the property. The trustee is the one holding the property in due course. Okay. A prime example of that relationship is a title on a car or a mortgage on a house, right? Those are perfect examples of trust relationships, three-party contracts. Okay. All right. So let me dig into it. Let me dig into signatures quick. And well, not quite yet. I guess I gotta get it out. All right, so we're going to get into the UCC tonight. So we're going to start off with UCC 3401. A person is not liable on an instrument unless the person signed the instrument or the person is represented by an agent or representative who signed the instrument, and the signature is binding on the represented person under section 402, which we'll get to next. A signature may be made manually or by means of device or machine and by the use of any name, including trade or assumed name, by a word, mark, or symbol executed or adopted by a person with present intention to authenticate a writing. Okay. So subparens B is saying how that can be made, and it's saying literally saying by anything, right? In the old days, they used to say, because a lot of people didn't know how to write. So they'd say, make your mark, right? Which was an X. X marks the spot, right? So according to the UCC, that's all that is required to bind somebody into contract is by a mark, right? So if a person acting, this is important because now we're talking about by a representative, right? Which is what we claim to be in the IRS system is the authorized representative. A person acting or purporting an act as a representative signs an instrument by signing either the name of the represented person or the name of the signer. The represented person is bound by the signature to the same extent the represented person would be bound if the signature were on the simple contract. If the represented person is bound, the signature of the representative is the authorized signature of the represented person. And the represented person is liable on the instrument, whether or not identified in the instrument. B, if a representative signs the name of a representative to an instrument and the signature is an authorized signature of the represented person, the following rules apply. If the form of the signature shows unambiguously that the signature is made on behalf of the represented person who is identified in the instrument, the representative is not liable for the instrument. Subject to subsection C, the form of a signature does not show unambiguously that the signature is made in a representative capacity. The represented person is not identified in the instrument. The representative is liable for the instrument to a holder in due course that took the instrument without notice. Okay, so let's go into here. 3302, right? Holder in due course means holder of an instrument. The instrument, when issued or negotiated to the holder, does not bear such apparent evidence of forgery or alteration, or is not otherwise so irregular or incomplete as to call the question to its authenticity. Okay. So, what would an example of an instrument where there's an authorized representative, a holder in due course? What instrument do we all deal with that would be,
Signing checks.
yeah, or the birth
We're the
certificate?
authorized representative.
The birth certificate is where I was driving. Okay.
Okay.
So the birth
Uh,
certificate, yeah, the birth certificate is an instrument, right? And it's been given to you, but it's not in your name. You are you are the one that's been gifted it, right? But the name on the top of it is the state. So the state is the holder in due course, right? So what a birth certificate is stock in the corporation.
Huh.
So if you're issued stock in the corporation, are you allowed to sign as an employee?
Yes.
Right. So because you're an employee of the corporation and because you're a stockholder, that gives you the right to sign for the corporation. Okay. So what this is talking about is in your representative capacity, right? Being able to sign or being able to put a signature on something as a representative, right? Because you're representing the corporation. So that's just the birth certificate, right? Another one is the driver's license, right? The driver's license application. In case you don't know, the driver's license is what creates the estate in that state, right? The estate is attached to the driver's license. So when you sign the application, should you qualify your signature?
Can you hear me, Kent?
I can hear you.
Oh, I'm sorry. I've been making some noise back here. I had no idea. This is the first time I've been on Zoom. Sorry,
Welcome.
everybody.
Welcome, Tim.
Hey, thanks. Um, so what was the question?
So understanding that a driver's license is creates the estate in whatever state that you live in, and you're signing the application. The question is, should you qualify your signature, or should you just give them a blank signature?
So by qualified, I have to have a definition for that just for me because I'm kind of a newbie here. So
Okay,
when
that's not.
you
No, that's
say
what this is about.
qualified,
That's what this is about, Tim. This is about learning, right? And so if there's something that you're not following, okay, so a blank signature. So when you sign something, you're signing as surety. You're saying, I guarantee this, XYZ.
right?
Okay.
You're
So,
representing, right?
right,
Like,
you're the representative and you're guaranteeing this, right? So, generally, what we experience this on is that something is done in the name, your all capital name, and then they ask you to sign. So basically, what you're saying is that I understand that this entity is dead and I'm guaranteeing performance,
right.
right? So when we qualify our signature, we are limiting or restricting what that is,
Oh, okay. Yeah. Yeah.
right?
Okay. Yeah.
So if you just sign Tim Walsh or Kent Stark or Brian Walsh and you're not qualifying it, then they
Right.
can do anything they want with it.
Right. Like it's kind of like like people were saying like under duress on like a complaint.
Right.
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 Okay.
Exactly. So if you're coming at in the capacity of the trustee, then you should sign it Tim Walsh, trustee,
Okay. Okay.
or authorized representative, or um, whatever, right?
Yeah.
Whatever the
Yeah.
capacity is,
Right.
beneficial title holder,
Fair
right?
enough. Yeah.
The only problem is that like what we need to really understand about beneficiaries is beneficiaries can't enter into contract, right? We are
Right.
represented
Right.
by a trustee,
Right. Yeah,
right?
but
So
yeah.
you
Okay.
don't ever like that's when I first came to the movement, they're all like, oh, sign as beneficiary, but they're like, oh, that makes the contract obsolete. Well, no, it dishonors the contract
Mhm.
because you're signing in a capacity that can't sign,
Right.
right? So anyway, so that's basically what we're talking about here is the different situations here when it comes to signatures. So then we're going to go to 403. Unauthorized signatures, unless otherwise purported in this article, an unauthorized signature is ineffective except as the signature of the unauthorized signer in favor of the person who, in good faith, pays the instrument or takes it for value. An unauthorized signature may be ratified for the purposes of this article. If a signature of more than one person is required to constitute the authorized signature of an organization, the signature of the organization is unauthorized if one of the required signatures is lacking. Okay. The civil or criminal liability of a person who makes an unauthorized signature is not affected by any provision of this article. Uh, if an impostor, by the use of mails or otherwise, induces the issuer of an instrument to issue an instrument to an impostor or a person acting in concert with an impostor by impersonating the payee of an instrument or a person authorized to act for the payee. So this is why court cases end up the way that they do. Okay, it's
Yeah.
because
Yeah.
we're imposters, right?
Yeah. And then when you come into a court and you are presenting yourself as well, in this case, as a trustee, right? Like as the authoritative person
Right.
over the trust, then you have a dominant stance over the court because they're expecting you to come in as somebody who is inept and unable to handle your own affairs. Is that right?
Right.
Okay, that's all. I'm just trying to figure it out.
1308 6C 1308.
Oh, I see.
All right, so 1308. This is one that comes to a lot, like a lot of people try and put this on documents. Performance or acceptance under reservation of rights. A party that with explicit reservation of rights performs or promises performance or asserts to performance in a manner offered by other parties does not hereby thereby prejudice the rights reserved, such as without prejudice under protest or anything else is sufficient. So basically what this is saying is that if you're not qualifying your signature by saying I reserve my rights and I give away none, then when you make a signature, they can make the assumption that you are waiving your rights. It's called consent and waiver. All court cases are based off of consent and waiver. So they're like, it's called implied consent. Well, you know, you're here, aren't you? Right?
Yes.
You're here, you're giving consent, right? So that's how they get you in jurisdiction is with the assumption. All right. So we're not gonna we're not gonna spend a whole lot of time tonight on this, but
Can I ask you a question real
yeah,
quick?
yeah, go ahead.
Okay, let's just say, okay, again, newbie stuff question. But you go into the driver's license bureau and you say, I'm going to do the driver's license or sign the registration, but you sign it with the qualification of you being the trustee rather than signing it with my corporate name, right? I sign it with, well, however it's spelled out, Tim Paul Walsh, and I say trustee. Like I put trustee on the license, right? Does that change the aspects of that thing, or does it still do those statutes and all those codes still uh, apply, right? Like because you're applying for a license, even though you've been granted the ability to travel freely in the United States since the Supreme Court ruling in the 80s or whatever. I'm just curious.
Okay, so trustee, when you're signing as trustee, you're signing as the legal representative of that trust, right?
Mm-hmm.
So by signing trustee, you are saying I'm responsible. I'm responsible for everything. So if you're signing an instrument for the trust, obviously you want to sign it as trustee. You want to say, I accept this gift to the trust for the beneficiary. I'm accepting it for the beneficiary as the trustee. But when you're signing a driver's license, which can pull you into a court in jurisdiction,
Okay.
you want to be the trustee?
I don't think so. I mean,
No.
I'm just like fishing here, but it answers a lot of questions for me, right? Like something simple like that would indicate to me that you don't necessarily want to do that because now you're pulling in the trustee into that sort of qualification inside of the corporate like embodiment of the law.
Right.
Does that make sense?
Yeah. So that's what you don't want to do, right? So
Right.
when I got my driver's license in New York, I signed agent.
Okay.
And the big joke was with everybody is they always they were like special agent Kent, right? Is what
Nice.
all my people up in New York were saying that, right? And it was funny, but the truth is it that makes me the registered agent. I'm the one that is representing that I'm not responsible.
Okay.
Right? Because like if you work for a company, you're not responsible for everything the company does, are you?
Right. You're underneath the umbrella of the
Right.
company's insurance and
Right.
the vehicle, everything, right?
But you sign as trustee, then you say, I am responsible for everything
Okay.
the company
Okay.
does.
Right.
Right. But you sign as agent and you're like, I'm an employee. I'm responsible for what I do, but I'm not responsible for what you do.
Okay.
Right. Does that make sense? So
Yeah, no, yeah.
when you get pulled into a court case, they are trying to create the assumption that you're a trustee.
Right.
Right. So it just depends. And this is where you get into capacities, which is what we're going to talk about next. All right. So
One
this
question
section,
oh,
this section here, employer's responsibility for fraudulent endorsement by an employee. Employee includes an independent contractor and employee of an independent contractor retained by the employer. Fraudulent endorsement means, in the case of an instrument payable to the employer, a forged endorsement purporting to be that of the employer, or in that case, in that case, in the instrument with respect which an employer, the issuer, a forged endorsement purporting to be of that of the person identified as payee. Responsibility with respect to instruments means authority to sign or endorse instruments on behalf of the employer, to process instruments received by the employer for bookkeeping purposes, for deposit on an account, or for other disposition, to prepare or process instruments for issue in the name of the employer, to supply information determining the names and addresses and pays and instruments to be used in the name of the employer, to control the disposition. So it just goes on and on about what responsibility is if you're signing as an employee of the corporation, whether a contractor or an employee of a contractor, right? So, um, and then B, for the purposes of determining the rights and liabilities of a person in good faith, pays an instrument or takes it for value or for collection. If an employer entrusted with an employee with the responsibility in respect to the instrument, an employee or a person acting in concert with the employee makes a fraudulent endorsement of the instrument, the endorsement is effective as the endorsement of the person to whom the instrument is payable. In other words, just because the person isn't authorized to sign, if the person receiving the instrument is in good faith thinking that that instrument is honorable, it is. And it has to be honored, right? It doesn't mean what you did by signing fraudulently isn't wrong. It just means that the person that accepted that instrument was under the impression that it was valid and therefore it was. So the company, the corporation is still obligated to honor it, right? Because they received it in good faith. Just because the person that gave it to them wasn't honorable, it doesn't mean, right? So,
Yeah, it's intention.
right.
Intent.
So that goes to that leads into talking about, right, when you give somebody $1, right? And this is like a prime example because this is something we do every day, right? So the $1 bill says, first of all, it's a promissory note, right? It's not,
Faith and credit.
yeah, it's not valuable in any other way other than the fact that I can hand it to you and you can spend it, right? So that's what creates value in that promissory note. But that promissory note, when you handed it to me in good faith, I was under the impression that that was an honorable instrument. So whether you were honorably handing it to me or not, it's honorable. It still spends the way it spends, right? So by handing it to somebody, you are essentially signing. Now, on a dollar bill, who is obligated?
The receiver.
The U.S. Treasury.
Oh yeah, tender.
Right. The United States is obligated. And who are they obligated to?
The people.
Correct. So if they're obligated to the people, why are they obligated to the people?
Well, the
Because
U.S. Treasury is a constitutional. Um,
the people are the beneficiaries.
Right, but why are they obligated?
Because they put our bodies up for collateral.
That's right.
what was that, Connie?
They put our bodies up for collateral with our
Okay, yeah,
statements.
okay, yeah. I just didn't hear it. I'm
So
couldn't.
in the bankruptcy, they pledged our bodies for collateral, and this is HR 192. Okay. They put our bodies up for collateral. So, we are the obligee, they are the obligor, and they have to pay our debts, right? They're using our bodies as collateral for the bankruptcy. So that means all debts have to be paid. So this is the backbone of this movement, is that because there is no money and because they're using our bodies as collateral, that all debts have to be paid. So this is your equity and redemption, right? Your equity and redemption is the birthright that we are gifted from God. But what's important to understand about this is we are to suffer with Christ. This isn't a gift where you don't have to do anything, right? We are to suffer with Christ. That means we are to pick up our cross daily. We are in the kingdom because of Christ.
Yeah, Pilgrim's Progress.
Right. And so we are to suffer with him. So that's what the bankruptcy is about. That's why they owe, and that's why we have the equity and redemption, right? But the important thing is to qualify or restrict what we are allowing them to do, which is, as a ward, as an infant minor, we're not doing that, right? We're just kind of like subrogating everything. It's just like take everything, pay everything, blah blah blah. So as you become, this, and then we get in the Corinthians. When I was a child, I thought as a child. When I became an adult, I put away childish things. So we put away childish things by qualifying our signature, right? So, I got some stuff here to show you what I'm talking about. So this is the Rourke stuff that I'm going to get into now. And for people that are just starting out, Tim and whoever else, these are the audios and the things that you're going to be given eventually. Everybody has these. We'll get these, and this is the stuff from Rourke. This is to teach you about equity. Okay, so signature, autograph, and capacity and equity within the Rourke materials. The act of signing and instrument is treated separately from the office, capacity, or trust relationship in which the signer acts. The written and handwritten name identifies the individual executing the instrument. The designation accompanying the execution identifies the capacity in which the act is performed. Rourke expressly addresses this distinction under restricted signatures. The manual explains that when the trustee intends to act in the capacity of trustee, the execution should contain a designated such as trustee, so that the act is identified as an act of that office rather than merely a personal act of the individual. The manual gives examples, including by so-and-so, by so-and-so agent, and autograph trustee. Accordingly, within this framework, by Stark, Kent Nicholas identifies the signer, the individual whose hand executes the instrument, right? It does not standing alone, establish whether the individual is acting as a trustee, grantor, settler, beneficiary, authorized representative, agent, or some other capacity. The relationship is identified separately by the designation accompanying the execution. For example, by Stark Kent Nicholas, capacity trustee for RF 707-5453 543-386 US Trust. Okay. The first line identifies the actor. The second identifies the office which the actor is acting. The third identifies the trust or principle to which the act relates. Right. So on something that we do a little bit more every day, right? It would be like by Stark, comma, Kent Nicholas, capacity, executor or beneficiary, and then for Kent Nicholas Stark estate. So that's something that you guys do every day. I was talking about the driver's license, right? The driver's license creates the estate. So what are you signing for when you sign for the driver's license?
The estate.
Right. And if you don't qualify your signature, what are they going to make you?
Trustee.
Right. Right. So that's an example of like what I'm trying to show you here that you do every day. Right. So that's why we want to qualify that. Right. You got a question? You want to say something?
No, actually, that makes total sense because you're signing your name constantly throughout the day,
All right.
whether it's a credit card or at the bank or anything like that. And you're just validating the system at that point, right? So you're like, it to me like newbie guy. It's all about them keeping you in the system at that point, right? Like you're just going about your business. You don't even know what you're freaking doing every time you sign your name, but it's all about how you sign your name. It's about
Right.
how you present yourself. That's just what I'm getting at. I know it's kind of
Yeah.
labor and listen.
So look at the Bible I created for you and look at all those documents that we went through and signed and look at every single place that you signed.
Yeah.
Every one of them is qualified, every single one of them.
Mm-hmm.
Right. So in a signature, when you're going to sign on a line, right, it should say underneath of it, like your name, trustee, your name, whatever, right?
Right.
And kind of like detail that out. And if it doesn't, that's when you qualify it and you say, okay, well, this doesn't say anything, and I want everybody to know that I'm the authorized rep. I'm the representative here. I'm representing, that person. I'm not the person.
Right.
So that's where you get into forgery. Like, one of the things that we do every day that people don't even know it is mail fraud. Every time you add, and they love it. They love it every time you go pick your mail up, right? Because the mail is written in the name of the estate,
Mm-hmm.
and you're not the estate, right? So they get you to commit mail fraud every single time because the zip code correlates to a graveyard in Washington, D.C. Right? So I'm going to show you some stuff on the trust that addresses that. But understand that the zip code, if you don't put it in brackets, now if I'm using the corporation or if I'm doing something for the estate, then I don't
Virginia.
use the brackets. It's dead. You can have it in the graveyard. I don't care. But when you're coming at me for whatever capacity that I'm in, it's going to be in brackets, right?
Okay.
And because that when you put something in brackets or you put something in a box, it means it is outside of the jurisdiction,
Right.
right?
So what about like on our trusts, for example, because those are private trusts, should we put all of those in brackets as well?
So if you're coming personally, then yes, right? Now I'm going to show you this in a second.
Can I say something really
You
quick?
can absolutely say something.
So also I I just want to add, and this is regarding so many discussions we've had, but you've got someone's middle initial, and people have to understand that when they're using your middle initial, they're actually referring to you as being the trustee or the fiduciary.
Yep.
So the first, middle, last is the estate, but when you get like a piece of mail and it's got your middle initial in it,
Right.
they're assuming or presuming, is that right? Can't say assuming or presuming that you're the trustee or the fiduciary.
Right. And sometimes you are.
Right.
Right. Sometimes we want that, but what this is about is teaching you when, like it's like that that Kenny is it Kenny Rogers? In the
No one to
hold
hold them.
yeah, no one to hold them and no one to fold them, right? And that's what it's teaching us. It's not that we don't operate in commerce, is that when we become private, we limit what we do. We limit how we do that, right? We have to do that correctly so that we don't end up being pulled back into a situation we don't want to be in, right?
Yeah.
Great
It's
stuff.
a position of power,
Yeah.
right? And strength, right? Like if you know where you stand, then people can't take that away from you. Pretty cool.
The Rourke Manual separately identifies the principal trust offices as grantee, grantor, settlor, trustee, beneficiary. That treatment is important because it demonstrates that the individual may occupy, act for, or execute documents concerning different offices. Thus, Stark Kent Nicholas, the individual signer, trustee is the trust or the office. Beneficial interest holder, separate trust capacity, authorized representative or executor, the capacity through which the signer may act. Kent Nicholas Stark estate, the grantor settlor identified in the instrument. The purpose of the identifying capacity immediately adjacent to the execution is therefore to show whose act the autograph represents in what relationship the individual intends to act and operate. Rourke's actual execution practice. Rourke's filed documents follow the same distinction. In one filing, the handwritten execution followed by the printed identification. Schwagerl Edward, trustee. So Rourke's a nickname, in case you haven't figured that out. His name is Edward Schwagerl. The name identifies the individual executing the instrument, while trustee separately identifies his capacity. Other Rourke filings similarly individuals as trustee, co-trustee, grantee, or other capacities other than treating the handwritten autograph itself as the office. His filed Minnesota trust materials, for example, separately identify Schwagerl Edward, trustee, and Schwagerl Christine, co-trustee. That's his wife. This is consistent with the manual and designation accompanies execution. Restricted execution and personal capacity. The practical reason given in the Rourke manual is also straightforward. It warns that if a trustee signs an instrument intending to act for the trust but fails to identify the execution as being as trustee, the transaction may instead appear to involve the signer personally. The manual therefore calls for the restricted signatures and associates the capacity designation with limiting the act to the intended representative relationship. Within that framework, a properly expressed trust execution communicates three separate facts: who acted, in what capacity, for what. The same person could execute another instrument differently, okay? The identity of the signer has not changed. The capacity through which the signer acts has not changed. So autograph versus signature in the Rourke material. Rourke also deliberately uses the word autograph. His manual actually instructs the student who practiced the autograph rather than the signature. It then pairs the autograph with the office, for example, autograph trustee. The manual goes further to describe the signature as something that can be noticed as an equitable asset. That part is Rourke's broader equity framework concerning property, title, and consideration. So in Orc's terminology, the autograph represents the act of the individual, while the appended words trustee, guarantee, and so on identify the relationship in which that is being made. Equity intent. This also fits into Rourke's broader presentation of equity. His named quotes Gibson for the proposition that equity looks beyond rigid forms, frictions, and technicalities of the real facts, rights, duties, conscience, and good faith of the parties. Applied to an execution, the important question is therefore not merely whose handwriting appears on the page, but what act was intended and in what capacity it was undertaken. For example, clarity in the execution block serves as the equitable purpose of making the signer's intent unmistakable. By identifies the individual performing the act. Capacity identifies the office or relationship through which the act is performed. For identifies the trust, estate, principle, or interest for which the act is undertaken. That is the distinction I would use consistently throughout the trust when following the work manual. Okay. So this is all going to be available to you guys. Okay. It'll be in the, so that you can read through this. So now I'm going to show you what I'm talking about.
Can I say something, Ken?
Yeah, go ahead.
So basically, what you just said, I'm going to try to recap that, but so what you're saying is it's in the manner that you approach whatever situation it is, how you approach a situation. Like, let's just say, like in medieval Europe, I'm the Duke of York, and then you're given a certain amount of authority and respect over the court, right? Like, or if you're a lord or if you're a king, right? So you're achieving a certain rank by the way that you present yourself, right? And that's like the signature actually is a bearing on that presence that you are asserting, right? And
Right.
so it's almost as if I'm the CEO of a company and I am King Big Cheese, right? And so everybody knows it in the room or in the atmosphere that you're presenting that as somebody with authority. And that's what it sounds like to me. You know what I mean? Like I am who I say I am, and thus you should treat me in the manner that I should get.
So the thing where, to understand in that is that, like, in the Constitution, Article 1, Section 2 says, having spent 25 years, having reached the age of 25 and spent 7 years as a citizen, I do claim my lawful claim of title of U.S. representative.
Okay.
Now, I'm paraphrasing. Okay. So once you get to that point where you are stepping out of the role of the ward or infant minor and into the major, right? U.S. representative, elector at law. That means that you're accepting the gift, right?
Yeah.
You're accepting the appointment, but you are also accepting the burden.
Right.
Okay. So it's not just that we're like, oh yeah, I want to be the trustee. It's
Well, you
like,
don't just get benefits by virtue of a title.
yeah. So equity says that if you if you if you bear the benefit, you bear the burden.
Right.
So the United States gets the benefit of our bodies. Therefore, they have to bear the burden.
Okay.
Right?
That's pretty awesome. I like the way that you explain that, because that brought it almost back to full circle when you first started.
Right, but that also goes to you, and all of a sudden, when you're not a ward of the state anymore and you're actually trying to be a U.S. representative,
Yeah.
right? Now you have the burden because you are representing. What are you
I want to
representing?
accept responsibility for my own life, but it also comes with caveats at the same time.
Right, but
Like you also have a return responsibility to me because this government was created for me, right? So okay.
so what are you being responsible for? So let's, say you do step out of the role of the minor and you become the major, right? And you're going to be the trustee. So if you're doing that, and that's what it says to do in the US written constitution, and you're a trustee now, who are you obligated to?
Yourself.
The people. All
Yeah.
the people. If
Yeah.
you want to stand up, I am man and I want to, or I am woman and I want to be an American and I'm going to stand up and take my birthright.
You have
It's
to
not
stand
just
up for
about the
everybody else's right.
it's not about the gifts. It's like now you're responsible for all the wards.
Yeah. You're
Everybody you
responsible.
come in contact with from here on out, you have to act a certain way. You have to be a certain way because you stood up and said, I'm not a minor anymore. I am the age of majority.
Yeah.
I'm an elector at law. Right? So how do we do that? Well, one of the first things you do, and this is what everybody does in the movement, right, is they start doing the elections, right? The IRS elections. Oh, I want to elect this. I'm going to elect to not do this, and they're like getting all into that. But like, really understand what you're doing as an elector. You're not a voter anymore, because a voter is what minors do. Minors tell the electors how to vote, right? That's what the electoral college is. That's why we don't have elections anymore. We vote and then our electors vote for us,
Yep.
right? So what it means to be an elector at law is that you are now stepping into that role and saying, I am an elector. So then you have a responsibility. As soon as you say that, the IRS isn't going to step in and take care of you. They're not going to say, they're not going to all of a sudden be like, oh, well, this is the right thing to do. They're going to be like, make your move.
That guy, we can't do anything with that guy until he does what he does.
Right. So
Yeah.
then it turns, once you become the trustee, then they're waiting for you to tell you what to do, for them what to do.
Yeah, because that's what we're supposed to do.
Right. Right. But like,
Right?
everybody wants to be the trustee and like sit there and get all the benefits, but nobody wants to stand up and do their thing.
Yeah.
Right. So that's where the issue comes in, right? Is that like do you have your toolbox set up so that you can do that?
Yeah.
Right? So whenever I get a letter from the IRS, I respond to it right away and pretty much like either I agree or this is fine or rescission or you're violating federal law or whatever, right? So like I got to know my position
Yeah.
when I'm doing that.
Can,
Go
can I
ahead.
say something?
Yes.
um, Another thing that I have found to be very helpful is in every single position that exists, know what your responsibilities and your obligations are.
Yeah.
If you're going to be a trustee, go into AI, whatever you got to do, and read what a trustee does. Once you read what a trustee is accountable for, which is probably the highest position in the land, nobody wants to be trustee. But if you're comfortable with that, then be a trustee, but know what a trustee does, because, or even a power of attorney or an executor or any position in that field, because a lot of people say, I want to be that, but you have to understand the responsibilities that go with that position.
Yeah, absolutely.
Yeah.
Absolutely.
And
All
you
right.
have to be competent at what you're doing as well.
Yeah,
And that
absolutely.
make based decisions rather than emotional ones.
All right, so we're going to start this out and kind of talk about some of this stuff, right? So here, declaration of trust in the presence of us in witness whereof. So then it's got these 4 signatures, right? The Walsh 4 here. So it says right above it what this is and what they're signing for, right? And then there's nothing below that says that it's anything different, right? And that says in witness, on this day, this is what I did. And then I'm signing it by Kent Stark, executor, authorized representative for the estate. So I'm the grantor. I'm signing for the estate. So you notice my signature itself isn't different. It's the same here as it is here. So the signature itself doesn't change. The authority underneath changes, right? So then, so this I put together to kind of detail some of this out. Okay, so grantor settler is the Kent Nicholas Stark estate. The grantor and settler of the trust establishes and creates and transfers property. The trustee is Stark, Stark Kent Nicholas, trustee of the trust, holds and manages and administers. Beneficiary is Kent of the family Stark, private citizen of the United States, non-domestic, without the United States corporation, located near Morgan County, survey landmarks, beneficial interest holder. Okay, so you see this is different. This is a different capacity. It's a different everything, right? Because this is the human body. This is the actual human body that's signing as the trustee. That's the guarantee, that's who's guaranteeing it, the surety with the signature.
Right.
But it's the same person, but in this one I'm the trustee, and in this one I'm the beneficiary, right? And then I created the nominal trustee, which is the bank, right? Which is a very
You,
important part
you
of this.
do you recommend we do this on our pure trust as well, where the
No,
creator is not that?
no. So the pure trust is totally different. You're not going to record it. You're not going to do any of that stuff. This is your private. This is getting recorded, right?
Right, but I mean like the creator of the trust that we fill in the line and the trust and
So
the
that's in the pure trust. It qualifies that, right? If you want to put one of these pages together through AI and like put it in your trust, like by all means do whatever you feel necessary to do. The reason why I did this is because I was having a bunch of shitheads not recording my trust, and they're like trying to fucking like imply different things. So I was like, fuck them. I'm gonna put a page in there, and so they can eat my ass, right? Like, go ahead. This is what it is. This is my declaration. This is what I'm telling you it is. Do not assume. All right. So, most important thing, other than this page here, which is the execution of the trust, is this page. Acceptance of trustee. So not only do you have to appoint a trustee, but the trustee has to accept. No, it's too small. I can't read it. All right. So, this is an actual constructive special notice by the trustee. I start Kent Nicholas in my citizenship status as private citizen of the United States, private member of the Union member state of Georgia, Georgia national, whose citizenship, blah, blah, blah. So I'm telling them who I am and what I'm accepting, right? So Stark Kent Nicholas, private citizen of the United States, non-domestic without the United States, located near Morgan County, 500 Indian Creek Trail, blah, 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 right? And so I'm signing and accepting that as the trustee. Stark Kent Nicholas, trustee. But it's telling you up here who Stark Kent Nicholas is.
Yeah.
And down here, it's qualifying it, restricting the signature to that's what this is, right? Now, when you're doing yours, you need to box this shit in. I didn't box mine in because I did this a long time ago. But when you're doing these yourself, when you get to these documents, you're going to box these in because you want to create a notary is an official signature from the state.
Is that the four corners rules, Ken?
Yep, that's the four corners, right? So if you box it in, that means that that jurisdiction is in the box and it doesn't apply to the trust. Right? So then here's the other trustee documents. Right? Again, everything is qualified through what's being said here. Kent Stark is signing as the banker. Right? Here, Kent Stark is signing as the grantee. Stark Kent Nicholas, grantee. Right? Stark Kent Nicholas, grantee without prejudice. I'm granting consideration, so title can pass. Right? Stark Kent Nicholas, grantee. So you can be the grantee or the grantor. The
You're just
grantee.
setting up parameters around each one of the different documents you're signing.
Yep.
Okay.
So then let's get into this a little bit, and then I'm going to end this because it's been a while. So these are documents that were actually filed and accepted on the record, right? So this one here was from the corporation that this asset is being brought in the trust from is the Postmaster General. And this is the registered mail number. And then I'm signing as Stark Kent Nicholas, grantee. So I'm accepting this from the Postmaster General and signing as an employee of the corporation. Right? So, and then that is being put into the book and page number, right?
Yeah.
And then I had to correct it because I make a lot of mistakes. And then these are all the notices. So we're not going to go
But
through
that
these.
goes to, I'm just guessing here, but that's one of the reasons you set up the EIN number, right? Like to be able to transfer, like signing as the grantee versus the trustee.
Well, so you have the grantee and the grantor, right? So one for here, the grantor is the postmaster. They're granting the registered mail number, and I'm accepting it.
Mm-hmm.
Right? So I'm going to get down to this next part, Tim, because this is going to make more sense when you get down here. Okay. So this is another one. This is an assignment and transfer of interest of what's called the silver bond.
Okay.
Okay. So this one here is assignment of transfer of interest. Grantee is assignee is Kent Stark, right? The grantor, assigner is Kent Stark, the person.
Right.
And I'm granting it to Kent Stark, the trustee of the trust.
Right.
So I'm accepting it
Right.
as these are two different capacities. So this is why there's no merger, because I'm signing.
It's just you're moving stuff within the corporation. That's
Right.
all.
Right. So with this one here, then this is how you report in the public that the authority of the trust, right?
Okay.
So state of Georgia, Kent Nicholas Stark Trust, or Kent Nicholas Stark Trust. Alternatively, registered mail number trust, right? So it's saying that these are all the grantors, right? And here's the trustee, and then it's executed with private witnesses and a public. So you see here, I put it in a box because this is a more current one that I did. So this is attached with these so that when people come across this, they know who it is.
Right.
Right.
Hey,
So
Ken,
yeah, go ahead.
I don't want to interrupt you. Keep going. Sorry.
No, go.
I just want to say that, I don't know if everyone knows Christian Walters always says, express the trust.
Right.
And expressing the trust is the kind of the same thing. What kind of the same is reporting the trust, and when you report a trust or express the trust, that's in court with the Secretary of State, with the U.S. Treasury, with the Department of Defense. We're talking, you know, all the departments within the United States and letting them know that that trust exists. I also want to express that I have a Bexley Halion trust, which there's some people that have seen that trust. That trust was created for my tax returns. And now, after going through Kent's process and seeing all of his foundational trusts, I always thought things had to be difficult and everything had to be in there. But this trust has to be done before a trust, like that kind of trust that I created, because this trust is a missing element that has to be done with the rest of the foundational trust. So I'm sure you agree with that already.
Right. So what I'm going to show next is this is what I created last night. So when in the circles with me and Constance here is that Constance created the Baxley Halion. If you don't mind, I can show it. I'll bring it up.
That's the trust that's offshore, right? In
No.
England? No.
No.
Hey, Ken,
yeah.
I kind of want to make it private. So a lot of people have seen it already, but I just kind of want to make most of the information private, if that's okay with you.
Boy, it's on the record, so that's anyway. So what I did is I went through, because what we have found out is that there's a living revocable statutory environment that you need to use for IRS purposes to claim your credits. This isn't necessarily that vehicle. Okay. This is going to hold those assets in the private, but this isn't the vehicle that you necessarily want to put this on the record. Don't get me wrong, but this isn't necessarily the vehicle that you want to use to claim the credits. This is what you want to use to hold, because this is the ultimate. This registered mail trust is the ultimate protective instrument, right? Because it is private and it creates a humongous separation of title.
Okay.
Last night I created this. It's a statutory. It's going to be recorded in Wyoming. And this is the IRS vehicle. Okay. This is where you collect all that. Now, one of the issues that a lot of people do is they don't create some sort of property to make this valid, right? So a trust isn't valid unless it's funded. And a lot of people say, well, I'm funded with the birth certificate, blah, blah, blah. That's not really how, especially when you're talking about statutes and things like that, it's not really how they see it, right? So I have another silver bond, and I had no idea. Understand, when I do some of the shit that I do, I don't have any idea why I'm doing it. I just do it. And so,
Could you do me a favor, Kent?
yeah,
Explain the silver bond.
I'm getting there.
Okay, thank you. I'll be patient.
All right. So here is the Schedule A. So the only thing right now in this trust on the Schedule A is the silver bond. So this is silver bond KNS SB 100172002. The other one for the other trust, which is in here, has got a recording number because it was recorded in Morgan County, Georgia, but this one is 001. Okay.
Right.
So this one is a different one, and it's got a different registered mail number, which this is when you're looking at public CUSIPs, that's something that is issued by the government. It's actually CUSIP.com is where the government goes to get all their CUSIP numbers. This is a private CUSIP. This is our ability to create CUSIP numbers through the registered mail, right? So Treasury Silver Bond. Here is the assignment and conveyance into trust with all the language that supports that. So in here, this living revocable trust for the IRS, it's Kent N. Stark, trustee, right? I'm using,
Yep.
so to explain this a little bit, is that take all the stuff that we're learning about this movement and put it aside for a moment. When you do a 1040, the name at the top of the 1040 that you fill out is some certain kind of name and then social security number. So generally speaking, what the name they use in that spot is going to be the Kent N period Stark with the social security number, because that is the fiduciary trust. It's its own trust, right? Consus found all this information, a while ago on what this is, but that's what that is, right?
Yeah.
So then that's the fiduciary of the trust. So then when you get to the Schedule C on the 1040, that's what's called the sole proprietorship. The sole proprietor is regarded as the owner. Sole prop is sole proprietor, the owner of the account. Okay, so according to the rules of equity, the beneficiary is regarded as the true owner. Okay, so if the sole proprietor is the owner, then it's the beneficiary. So now you're looking at the 1040, and we got the trustee, you got the beneficiary, and then you got the estate, which is what it's all about. Is the estate is the all caps name is the estate, right? So you have the trust. So what we're doing in this in this trust, and some people do it differently than I do it, but the way that I'm doing it, I'm using the name in this situation because so Kent Nicholas Stark Living Trust, and the fiduciary is the Kent N. Stark trustee and the Kent Nicholas Stark Living Trust. And so if you go to the top of this, Kent Nicholas Stark Estate is the grantor, right? And then if you go to this, because everything that I do like meshes in together. I'm going to get into the silver bond here in a minute, but everything here meshes in together, right? So here's the estate notice, right? Kent Nicholas Stark Estate, testator, and intent and filings. The estate was registered, the Postmaster General, right? So this is the estate notice that I put out on the public record, which is what created this private trust, right? This one. And so now I'm taking that estate and I'm creating a living statutory trust for the purposes of filing tax returns. So their trust that they create is an implied. And an implied trust has a lower title than an express trust. So all I'm doing is taking their bullshit and I'm expressing it so that I can create an environment where I have the superior title, right? So this is, and it goes into all that. I mean, like, for example, 3, I think it was purpose of the trust. The trust is created to provide lawful structure for the ownership, holding, protection, management, investment, administration, use, and eventual distribution of property transferred to the trust, right? Which there's already property in the trust because the IRS has been putting it there since 1972.
Bretton Woods. Anyway.
Yeah, and so this goes through and it details all those things that this thing is claiming. Okay. So tax information, tax identification, tax returns, and fiduciary rulings, and it lists all the things, 1099s, informational returns, and all that, right? So, but it has to be funded, so I used the silver bond to fund it. And let me find it. Here it is.
Well, the silver bond is pre-72, obviously.
The silver
Right.
bond is a trust relationship that I created. This is a debt instrument. And this is created in the justice of, well, first of all, it's created under the Constitution because 21 pieces of silver.
Mhm.
The Constitution says that it should have jurisdiction over everything over $20. So the face value of these coins is $21.
Mhm.
Now, the actual value of them is irrelevant, but it's well over 1,000.
But you're basing it on the Constitution,
Right.
right? So like the actual.
Right. And this is the law of suretyship, right? So down here, witnesses, silver bond, creator, and secured party. So this is basically creating an environment where the I'm using the silver and conveying it with a bond, right? So basically, this is the same thing as a silver certificate, right?
Yep.
The
Yep,
United
it's
States doesn't honor the silver certificates anymore, so I created a silver bond. This specific one went to the Treasury. This one isn't recorded in any statutory environment. This is recorded with the Treasury. And I'm using my private registered mail number, my private QSIP, right?
Right.
So this indemnifies the trustee with that instrument, which is the silver or the living revocable trust that I'm going to use on tax returns, right?
Right.
So the grantor of this is the estate. The recipient or the grantee is the body, the person that is being the trustee of the trust. And so then this is sent to the Treasury, and then this is conveyed in the trust using the assignment, right? Which is right here. And so this goes deeper into the signatures, right? Acceptance of trustee signature, right? Execution, settlor grantor signature. It's qualifying it. It's qualifying everything. It's not just a line sitting there. It's qualifying it and saying this is who I'm signing for. Right? So what gives me the authority? What gives me authority to do that?
You're acting as the trustee.
Right, but what gives me authority to sign as the estate, as the grantor? What gives me that authority on that trust to sign as the estate?
You're the authorized representative.
I showed it to you.
Silver certificate.
No.
All right.
I'll show you here. It's all going to make sense to you in a second. This is what gives me authority.
Okay.
This declaration of trust is a formal written express trust indenture of the special trust relationship between the parties for all accounts in the corpus res of the trust belonging to the estate of Kent Nicholas Stark. The estate
Declaration of
of
trust.
Kent Nicholas Stark. All property owned by the estate is now owned by the trust.
Okay.
That's this one here. The private instrument is what gives me authority on this.
But you have to go through all these different processes to link this all together, right? Because there's like a common law constitutional link between everything that you're doing, right? Like you're linking everything together into this document. Is that correct?
Yeah. Everything is
Okay.
about this. This is like, that's
Yeah.
the advanced trust is that one, right? So
Right.
everything else we're doing, the heaven and earth trust, right? So that's the first time when God gives us authority. And then we
Right.
created the pure trust, right? And so that's where we're taking that authority and putting it into a private instrument, right?
Okay.
And then
Yeah.
we're taking that and we're creating some other environment so that we can do that private trust,
Yes. Okay.
right?
Right.
And so
Right.
that private trust is where we're putting our claim out there that this is our estate, and then you're putting it on the record, and then you're putting a public notice and you're saying this is what's up. And then you're
Okay.
creating another instrument. So the last trust, right? For
Declaration of trust.
Constance, it's Baxley Halion. For me, it's the Kent Nicholas Stark Living Trust becomes property of the other trust. So you're going to
Okay.
claim all that IRS shit in that statutory trust, and then you're going to put that trust as res property in an annex in the other trust.
Okay.
So that's how you protect it. This is where everybody screws up, because not really screws up, but this is where everybody misses out, because you can't take something that you can't protect. You can't go to the government and say, I want my credits. But if you can't protect it, right? And this is where they laugh at you, because all they do is they throw you in a courtroom and they're
Right.
like, well, let's see if they can protect it.
Well, and that's the whole idea behind I'm just guessing, but that's the whole idea behind all these so-called socialist programs of Medicaid, Medicare, and all these other things is that they are caring for people who cannot take care of themselves, right?
Right.
And so they're giving something back out of whatever they have, right?
Yeah.
Back to the people, but you are considered a under 25-year-old person. I'm just guessing. I don't know.
Yeah. So until you tell the government you're not 16 or 5 anymore, they assume that you are.
Yeah, fair enough.
Right.
Okay.
So you got to let them know. So the first
Well, I'm
thing we
just
do to
looking at
let
the
them
big
know
picture. That's all.
is we get the,
It's just really interesting.
yeah, the first thing that we have to do to let them know that we're there is the birth certificate. We get that
Mhm.
double authenticated, and then that creates the environment where we
Yeah.
are
Yeah.
letting
I'm
them
taking
know,
my
hey, we got your gift.
I'm
Thank you.
taking my shit back. Is
Right.
what you're doing. Right.
Well, you're just basically saying that thank you for holding that for me. I got it from here.
Right.
Right. So that's where you get into the surrender stuff, right? So once you claim all your shit in your trust, and then you put it in your private trust as res property of it, then you collapse all the other bullshit that they created,
Yeah.
and you have your interest, your revisionary interest.
Yeah. Consolidate.
Yep. So that's what all that is. And then once you do all that, then you have the pure trust where you can put property in, and then you have the private trust, right?
Uh-huh.
Which is where you're claiming everything. Once those claims actually become actualized, they go into the pure trust. You can't keep shit in a revocable trust because there's no protection,
Right.
right? So you got to move it into that right? So
That's
whether you
why
buy
you
a
had
house or a car
that's
or
why
get
you
a
had
bank
the
account,
EIN though. That was one of the reasons you set that up right away, right?
right?
Okay.
So, yep. So that's kind of like what that is, but like for the purposes of tonight, what I wanted to really go through is these signatures and like show you guys like what that is, why you're signing the way you are, what that means, and so that when you can move forward and sign signatures, you're always gonna like um qualify it the right way, right?
Right. That's pretty awesome, dude. You did
Yep.
a really nice job. That's all I'm saying. I don't know if you're done or not, but that was a well done presentation.
Well, I appreciate it. I'm glad you came. And
Mm.
it's like this is how I'm a trustee. This is how I want to be a trustee for people, right? Is that I want to teach and I want to show everybody how to operate, right? And how to like actually operate, not like, not like give all these pipe dreams about all these wonderful things that are going to happen to you. It's about like I want to teach responsibility, about how we stand up and get counted, right? So I don't know. Some days I feel like I'm doing it, some days I don't.
You're doing a great job, bro.
No, I'm just saying, like, you've got your, and I'm not trying to pump any sunshine up anybody's butt, but like, you're really well organized, and I appreciate that, and you can answer questions. So, to me, that means a lot because I have to visualize I can't look at anything. I have to visualize it on my own. So it works for me. So I appreciate that.
Cool. All right. Well, that's all we got for tonight. I appreciate everybody for coming. This is recorded and this is going to be this one will be on YouTube. Um, so um, I really appreciate everybody's input tonight. So, all right, everybody have a good night. Thank you.
Yeah, man. Good job.
Kent,
Bye.
appreciate